Now this morning, as in the great opera by Puccini, Turandot, where 3 secrets had to be unravelled in order to gain the princess, I'm not trying to get the princess, but I am trying to get you to be true to the progressivist view that you have espoused by coming to this conference. And so I am going to throw down 3 challenges to you. And I hope that during the course of the day you may consider taking them up. You don't have to, but it's something for you to think about. You have a very interesting program, and I wish I could stay all day, but I've got other things to do back in Sydney, another conference to go to later this afternoon. But I do applaud the fact that you have put on your agenda the 3 issues which I regard as very important: environmental law and practice, and how lucky you will be to have Chief Justice Preston coming to speak to you of the New South Wales Land and Environment Court. I can tell you, as somebody who goes to endless conferences overseas, that the Land and Environment Court of New South Wales is famous around the world. Most of them haven't ever heard of the High Court of Australia, but they have heard of the Land and Environment Court, because it's a court at the cutting edge of the defence of the environment and the rights of civic and community groups to defend the environment. So it'll be a great privilege for you to have him, and it's to his great credit that he's signed on and he's going to be here and he's on his way at the moment. I am not going to speak about that subject because I wrote a brilliant essay which was published last year in the Law Quarterly Review. If you want to get radical ideas, liberal ideas, progressivist ideas into the mind of the power forces in our world, you don't only go to the Alternative Law Journal, though I do read that and subscribe to it. You have to get into the establishment journals, and there is no journal in the whole world that is more establishment than the Law Quarterly Review. It's been going for 150 years, and it used to be called the ultimate appeal of the British Empire. When you lost all the way up and you lost in the Privy Council, you still had the Law Quarterly Review offering home. And in the Law Quarterly Review last year, the editor published an excellent article by me which asked the question, why are judges hostile to public interest litigation? Why are judges hostile to public interest litigation? Why is the common law hostile to public interest litigation? And I do urge you to have a look at that, because it propounds the thesis that there are 3 areas where we can see the hostility exhibited. One of them is in the issue of standing to sue. The fact that the common law has generally required a financial interest in a case in order to allow the case to progress. Otherwise they say, oh, this is just a busybody. Community groups and civil society are often very concerned to make sure the law is obeyed. And their interest is not that of a busybody, but somebody truly seeking to uphold the rule of law. But if they don't have a financial interest, generally they don't get past the front gate. The Law Reform Commission, under my chairmanship, has put forward a proposal to make the gate, to replace the locked door with a fly screen, as we put it, something that would keep out the flies and the busybodies, but allow through the civil society and other organisations. But so far that has not been enacted. But meantime, the courts have loosened it up a bit, but standing is one impediment. Another impediment is costs. The rule that normally the loser pays all the costs. And in a very important decision in the High Court, in Oshlack against Richmond City Council, an appeal ultimately from the Land and Environment Court, the High Court by majority, 3-2, Justice McHugh and Justice Hayne dissenting, held that a decision of Justice Steen in the Land and Environment Court, not burdening a community group with the costs of litigation, designed to uphold the Land and Environment Act, that decision was a correct decision. The High Court reinstated it after the Court of Appeal in New South Wales had displaced it in the name of the general principle that the loser pays the cost. That was a case where a community group wanted to uphold a contention that the local government authority was not maintaining against the developer an environmental rule which defended local fauna, in this case a community of koala bears. And the community group pursued the matter and they lost before Justice Steen, but he still said it was a proper matter for them to pursue. And he said, under the Land and Environment Court Act, I don't have to order costs against them in the public interest. And that was the question in contention, and ultimately the High Court in that case upheld his decision. But it depended on a specific provision in the statute, and that is something that maybe you should consider. The third impediment is the impediment of interventions, amicus curiae. And in the High Court, right from the beginning, I had a large number of cases where interventions were rejected, and people who sought to put general principles of law from a disinterested or general group of view were sent away. The most astonishing to me instance of that was in a migration case, a refugee case, which we were hearing in Brisbane, where the High Commissioner for Refugees of the United Nations, of the world, sent a barrister from Australia to appear before the High Court to seek leave to intervene to explain the provisions of the Refugee Law Handbook issued by the High Commissioner for Refugees, and the right to give an oral intervention as an amicus curiae was refused, although it's a commonplace, including in many English cases, to give leave to the High Commissioner for Refugees. So there's a great hostility to interventions of that kind. I see Justice Preston has arrived. I will mention what praise I've been heaping on him and on his court, and how famous his court is overseas. When you go overseas, more people know about the Land and Environment Court of New South Wales than about the High Court of Australia. And so I'm very glad that he's going to be following me later in the day. You also have a session on Aboriginal rights, and as I've said, back in my youth, no one talked about Aboriginal rights. I don't remember ever anyone in my law course saying there is a fundamental injustice in denying people, the Aboriginal people, the right to land. I don't remember that ever being raised, that there was ever any injustice on it. We continued the notion that they were just a group of primitives, nomadic, tribal people, and the denial of land rights was entirely fair, reasonable and just. And it took the High Court of Australia, not an elected parliament, to change things. The third session is process and legal aid, getting people to justice. If you go to law admission ceremonies, and I've been to endless such ceremonies. When I was president of the court, it was sometimes my duty to conduct such ceremonies, and the self-congratulations of the law on such occasions is truly uplifting. But sometimes we've got to make our practice match the self-congratulations. And getting to court is often a big difficulty in our system, not least because of the type of problems I mentioned. And that brings me therefore to three gauntlets that I throw down to you for your consideration during the course of the day. Justice Preston's excused from this because he's a public officer, but you're not. You've got to consider it. The first is in relation to the controversy which is circulating in our country at the moment concerning marriage equality. That is a matter which is under consideration in a Senate committee at this time. I'm encouraged to raise this with you because most of you are, or recently were, students. And I got an email this week from the Australian Medical Students Association saying that that body had unanimously agreed to send a submission to the Senate committee indicating that not only as citizens did they support the notion of the right of marriage equality to all people in our country, but that from a point of view of health, it was an important feature of relationship law that it should be equal, and that those who want to be married should get married. It's not compulsory. Some people won't ever get married. Some people are quite happy not being married. My partner of 43 years and I are not absolutely sure we'd get married, but we sure support the notion that those for whom it is important should have that right in a fair, democratic and secular community. Everyone respects the right of religious organisations to deny marriage in their temples. Their temples should be respected. That is a matter of the respect for religious beliefs. But in a secular community where 2/3 of the citizens now do not get married in a temple but get married by a marriage registrant, where the right of marriage is granted by federal legislation, where it is granted under the constitution of this country, which contains a prohibition on establishing any religious belief, where the religions should be protected in not having to marry, but where those citizens who believe they should have this civil status granted by law should have the facility. It's at least something for you to consider whether or not you believe that this organisation should send a similar submission to the Senate committee. There will doubtless be some in this room who don't agree with it, but if it were a majority view, as I suspect it might be, something of that kind should, I think, be said, because there are times for silence, but there are times to speak up.